Senator from Charleston, Senator Sinn, what purpose do you ask?
To see if the senator would yield for a few questions.
Yes, ma'am.
Senator, yes.
So I'm looking back through your bill, and after listening to the testimony of my seatmate, or his questions, and you indicated that telemedicine was not enough, that somebody would have to be seen face-to-face, patient would have to be face-to-face. In looking back through it, I do see that the patient, at least initially, would have to come in face-to-face, but I don't see anything that says that the doctor has to fact-check, for instance, what was the underlying cause. It looks to me like the patient can fill out a form, tell the doctor these things, tell the doctor whether he's had mental health issues, tell the doctor, you know, what his debilitating injury is, and the doctor could simply accept that and then put it in his records. Do you see anything different?
In the initial authorization or in the renewal?
Well, the renewal, I think, can be telemedicine, can it?
Right. I'm talking about in terms of that initial authorization.
Yeah, the initial.
But again, it's very, in terms of what that doctor has to certify, Senator from Charleston, it is the doctor's analysis, not just, I mean, of course, you got to communicate with the patient and you've got to hear what the patient is saying. I mean, that's critical to any diagnosis a physician makes. But at the end of the day, in that certification, it is that physician that is certifying those things. It's not just simply, you know, cutting and pasting whatever the patient says. And if, in the event, I go back earlier, if a physician doesn't discharge those very specific duties, he or she is subject to sanctions by the Board of Medical Examiners.
Well,
now,
that's my next question,
Yep.
but let me go back up on this, because what I just read it over again, it does not appear that he has any duty to check what other meds the guys or girls are on, what type, if there was an x-ray or anything like that. It says they can, but there is no duty to do that. The physician could simply get someone to fill out a form, certify him, put it in a file, and after that, they can have a telemedicine relationship. Is that right?
no, I don't think so. Let me hold on. Let me pull up the section here.
It's going to be 44, 53, 22, 60.
Hold on, let me pull the document up. Excuse me. Say it again,
Wait, no,
Senator
no,
Charleston.
I'm sorry. Gave you the wrong section.
Okay, I've got it now. It's section 44-53-2080,
Okay.
talking about the written certification that a physician has to issue prior to authorizing a patient to access medical cannabis.
Yes, I agree
and-
that he has to certify, but there's nothing that says what can constitute the certification. My point is, if you have seedy medical providers, they can simply say, hey, dude, have you ever taken any other kind of medicines? Do you have a mental health problem? Why does your knee hurt? That's okay.
No. Section 44-53-2080A3 says that a physician must sign a statement and attest to it and sign it with the following provisions: that the physician has done this. They have a bona fide patient-physician relationship. That the physician has consulted the prescription drug monitoring program, that the physician has conducted an in-person evaluation and collected relevant clinical history, including history of present illness, whatever, all those things, that the patient has a debilitating medical condition, that the physician has developed a written treatment plan. I mean, these are all declarative duties that a physician has, and then he signs a certification saying that it is true. Now, if you're asking me, are there going to be some physicians that take shortcuts and that simply cut and paste and take whatever the patient says? I can't get into that physician-patient room and tell you with 100% certainty what's going to happen. What I can tell you is this section is very declarative in regard to what a physician has to do, or he or she is subject to penalties. It's not discretionary. It's not they can do it if they want to. It is what they have to do and certify to in writing.
I'm trying to make sure we're in the right spot, because I am looking at...
I just read you the spot where it establishes the duty.
You said 2380?
It's 44-53-2080, paragraph A, so paragraph 3.
Hold on. Okay, it gives the minimum standards, but I don't see anything that indicates that this doctor can't just take what the patient says as true.
Well, Senator from Charleston, I don't know how else you can say it other than to say a physician must have a written statement attested to that by physicians saying that he or she has done this. I mean, if you want to put in some...
Right, but the qualification could be, I have asked the patient, he said this, and I'm going to certify that the person has a hurt knee.
I would submit to you that's not how this language reads, that this language is very detailed in regard to the diagnoses that a physician has to make. But if you feel like there needs to be other language put in there that makes it more declarative in regard to what a physician has to do, I'm open to amendments in that regard. I feel like it's fairly clear. I think that somebody looking at this section would conclude that it's clear. But I'm not going to argue with you. If I want to get your vote, if you don't think it's clear enough, offer up an amendment. And if it does make it clear, I'll support you.
Very good. So I see where doctors will have to go to a 3-hour course to start prescribing marijuana. Would that, and that in your view is enough for doctors who don't prescribe marijuana to figure out what type, all of that kind of stuff, 3 hours?
A lot of states don't have any, but we put that in there at the request of the South Carolina Medical Association. And it's not just the one course, it's an annual 3-hour course in the therapeutic benefits of medical cannabis.
Well,
if you feel like some other layer is necessary in order to make a physician competent to make a diagnosis, I can look at that amendment. I can just tell you that is what we came up with in talking to the South Carolina Medical Association and what they felt like an appropriate time would be.
So also in looking at some of these subsections, I see that you're giving physicians immunity for being sued for malpractice.
No, that's not true. That's not the case.
44, 53,
Yep.
2290, and then there's another section. Hold on.
Yep, I'll get to that because I remember discussing this. I'm sorry, Senator Charleston, what section were you looking at?
It's 2290, but there's another one. Hold on.
$22.90.
And 4453, 2090, subsection B.
Okay, here's how it reads. A physician may not be sued for medical malpractice as a result of certifying a qualifying patient's medical use of cannabis products in accordance with this article. However, the immunities provided by this section shall not be construed to prevent a physician from being penalized or sued for violating the standard of care or for any violations of this article, including certifying a person for medical cannabis products who does not have a debilitating medical condition. So in other words, we are not creating a carve-out from having to conform with what the standard of care for a physician. What we're saying is that simply as a matter of qualifying somebody for a condition, that is not sufficient in and of itself to sue a physician for malpractice. However, if you can demonstrate that the physician did not do that examination correctly, did not make the right diagnosis, did not complete that certificate in good faith, violated the standard of care, that doctor can be sued for malpractice. And so to say that there's immunity from malpractice isn't correct. You got to read the rest of that sentence.
Okay, well, I did, and then I'm looking back over here, 4453, 2090, subsection B. Again, it talks about a physician not being subject to being arrested or anything else with respect to issuing these certifications. Now, what about if they
What section was that?
I'm sorry, it's 4453, 2090, B.
2090. $20.90B. Right. A physician is not subject to arrest by state or local law enforcement, a prosecution, or penalty under state or local law for providing written certification. That's simply a recognition that if this law passes, it is legal for a physician to authorize medical cannabis use by patients if that physician complies with all those requirements. It's not illegal under state law.
And then let's get to the medical standard. The doctor's going to know the medical standard based on 3 hours of education that's going to be given by the Board of Medical Examiners at some point.
I think I think it's a matter of fact as to what the standard of care that's required in any given circumstance is. So this isn't, I mean, that 3 hours of medical education doesn't provide a physician with a safe harbor from being subjected to a malpractice claim. It is simply a statutory requirement because we believe it's in the public interest of South Carolinians for these physicians to have that training. But it doesn't go to creating a safe harbor in regard to the standard of care.
If marijuana is a medicine, is there any other medicine that you can think of where the statute that allows it and enables it provides immunity for doctors for prescribing?
It doesn't provide them with, well, it provides them with immunity. It's not illegal per se, and it's not malpractice per se, but it goes on to say that you are still subject to the standard of care. So if it turns out that you have authorized the use of cannabis by a patient, and if it turns out that that was completely wrong, that this person had a history of mental illness or a tendency towards schizophrenia or any number of things, you can be sued for malpractice because you have not discharged your requirements under that certification. So it doesn't create a safe harbor, but what it does say is that in and of itself does not constitute evidence of malpractice.
I am confused as to how we can deny people who have been, I guess, given these medicines, since they are medicines, the right to take them. And I understand that you've carved some things out with respect to employers where they're truck drivers, and I think even CWP holders are not supposed to have it, right? If you have a concealed weapon, you can't get your medicine. Police officers. I saw in one section where police officers and first responders are automatically entitled to get a diagnosis of PTSD just by virtue of the fact that they're first responders. Yet, then you say that the employers can mandate that they not, first because they have a weapon, but that they're also first responders and they need to be cognizant. How can we deny people medicine?
There's two parts to your question, and I'll answer the first one. I have certain CLE requirements as a lawyer every year that I have to take. That in no way mitigates my duty to provide a degree of competence to my clients. Okay, so that's the first point I would make. It's a requirement, but it is not an insulation from liability. Secondly, as I was saying to the senator from Greenville, what we're doing here in this bill is we're weighing the rights or the ability to give patients access to medicine and what that entails and the benefits there. And we're looking at the other side of the scale what some of the societal consequences might be. Workplace, taking away control of workplace might be one of those consequences. This is the balance that I've struck, okay, or that we've struck in committee in regard to how do we weigh those competing things.
Is there any other I'm sorry, yes, sir.
My answer. So as we go about crafting a bill like that, there's a whole myriad of things that come into the equation, and engagement with the Chamber of Commerce and with SLED and with others. This is the balance that we struck in terms of providing access to patients who need the medicine, as opposed to what some of the competing societal considerations were. This is the balance that was struck there. It is not an absolute, as you point out. It is a striking of a balance there. And ultimately, that's what we do in passing laws, because every law that we pass has an impact on something else, and you have to weigh the relative merits of each. That's what we've attempted to do here.
Is there any other medicine that you're aware of that can be denied individual classes of people?
I don't know. I don't know whether or not opioids or opiates or certain prescription drugs. I mean, certainly in a private employment context, there's going to be restrictions in that regard. I guess your question to me is there one in statute? I'll have to check and see. I'm not aware of one. But again, the reason that exists here is to balance those two competing things. And some may agree that I've sided too much on the side of what law enforcement wanted, or what the trucking industry wanted, or what the Chamber of Commerce wanted. Some others might say I sided too much on the side of individuals having the right to access medicine. we've done the best job we could in trying to reconcile those competing societal interests.
So I'm just curious, though. I understand that you're trying to please everybody, but I'm worried that it runs afoul of...
I'm not trying to please everybody. What I'm trying to do is
balance.
listen to everybody, understand their concerns, and then, as lawmakers must do, decide how you're going to come down and striking that balance. So I'm not going to, in fact, I'm probably making everybody angry in this to some degree. I'm not satisfying anybody. But what I am coming up with, what I'm presenting to you, I hope, is the reflection of 7 years' work, listening to stakeholders, and trying to balance the legitimate interests to come up with a product that does the best good.
Right, and trying not to mince words with you. I hope you didn't take it as such. But
No.
it just seems to me I don't know of any other class that can be, parted out like CWP holders and not included in something like this. And then the bill goes even further. It says, and this I think may be another equal protection issue, if someone is between the ages of 18 and 23, they have to have 2 physician certifications, right?
Yep.
So how are we possibly, these are adults, they can go to war. How are we possibly saying that they have to have 2, and then is the insurance company going to pay for the second consult?
First of all, in regard to the equal protection argument, there's not an equal protection issue here for this reason. There's not a suspect class involved, so you're not dealing in a situation where there's heightened scrutiny, okay? We're talking about equal protection in terms of treating different non-class groups, non-special class groups, and all you have to have as a matter of public policy is a compelling argument or a rational basis from drawing the distinctions you do. I feel confident that the distinctions that we've drawn in this bill in regard to who can consume medicine and under what conditions satisfies that lowest level of scrutiny that the Equal Protection Clause requires.
How so, given age? You're discriminating based on age. They have to have another doctor's appointment that I don't see in here that the insurance companies have to pay for because of their age, 18 to 23. And why pick them?
I think it's important because when you're younger, developmentally, marijuana acts in your system in ways that are different than when you're older.
Yes.
I think it's also arguable that as you're older, you get more experience, you have more maturity. I think that for those reasons, requiring 2 authorizations in regard to that bracket of ages is a rational basis for a public policy.
And do insurance carriers have to pay for the second one?
Insurance carriers don't have to pay for either one. I mean, okay, the insurance industry came in and said, we want a provision added in there that makes it clear that we're not obligated to pay any claim or to pay any reimbursement for people accessing medical cannabis. That's why I have been very clear in keeping the fees down to just what is necessary to cover the cost of DHEC's program, because I recognize that most people are going to be purchasing this out of their pocket. And unless they have an insurance policy that covers it, this law makes clear that there's no mandate. They're not mandated to cover it.
Sir, I agree with you that it said that they don't have to pay for the product, but it does say that they have to pay for any consultation that would be covered.
I misunderstood you. I thought you meant the product itself.
No, I'm talking about if I could go and say, Doc, I need this because I'm debilitating, I have this horrible pain, and I have to have 1 visit. So you're discriminating, though, based on age when the 23 and under crowd have to have 2 visits. Will the carriers have to pay for the second visit?
The answer to that question is I don't know. You're right that there is different criteria. I would have to check and see whether or not they would have to pay for the second certification as well. I'd be happy to check that for you.
Okay, but then back to the question. You said between 18 and 23, there's some developmental issues. In fact, you've probably seen the studies where their frontal vortexes are not basically fully developed, and marijuana harms the development of the frontal vortex. Have you seen that?
It can. I mean, look, I'm not here to say marijuana is a panacea. I'm not here to say that marijuana smoked heavily by teenage youth can't have an impact on their cognitive abilities. It can. It can, absolutely. And I would be the first to say to you, I would discourage my daughters from smoking marijuana. But again, what we're talking about here is something completely different than a teenager smoking marijuana recreationally. What we put into place here is very tightly regulated and controlled, and I just think this idea that somehow by authorizing cannabis in this oil form to help out patients that have one of 13 special conditions certified by a physician after an inpatient diagnosis is going to lead to increased teen recreational use. I just don't believe it.
Do you consider vaping smoking?
Excuse me?
Is vaping smoking?
It's not burning leaf. It certainly is heating the oil and inhaling it.
Right.
I mean, we're in a semantics game here. I don't know if you want to call that smoking or not.
Well, you're talking about smoking marijuana. I think you and I would never recommend that our children smoke marijuana. But now you're making extra hoops for people to jump through that are 23 and younger. So are you also acknowledging it's not just smoking? It can be gummies, it can be brownies, it can be these oils, vaping.
I think you're making a fair point, and in fact, you're making my point, is that the reason that class of individuals is treated differently and needing two certifications is because marijuana at that stage in their life could potentially be more problematic. This was an attempt to go ahead and wear belt and suspenders, okay, and making sure that before you can consume cannabis in that age group, that you have two qualified physicians saying, this is something that you need to address this underlying condition that qualifies. That was the rational basis.
And I appreciate that. And you've made this same explanation over and over again for all of these various holes in the legislation. You have done your best to do the best you can. And I'm going to sit down and let you move on to other people's questions. But at the end of the day, when you're looking at this legislation as a whole, try as you might, and you've done it the best you can, there are still lots of areas where kids, people can get into trouble with this type of...
It's not.
Okay, thank you.
Well, I will say this, though, before you sit down, in terms of the education that a physician has and the 3 hours that the bill requires, and is that did you know, and you probably know, because MUSC is in Charleston, and you're from Charleston, that they hold an annual conference about cannabis medicine that is heavily attended by physicians, in which the best cannabis doctors, PhDs, physicians come in, and they get credit. They get continuing education credit. That's taking place now. It's taking place tomorrow. There's one tomorrow. In fact, I'm a panelist on it. So you've got medical universities now that are engaging in this subject area. They're engaging in this space. I mean, and that goes back to a point that I made earlier. Older doctors, older physicians tend to be more resistant to this than younger doctors because the use of cannabis as medicine is a relatively recent phenomenon in the last 20 years or so. So you're starting to see in medical school curriculums these sorts of things. So the idea that we're foisting a medical cannabis law out there on a population of doctors that is completely unprepared to do it, I don't think that's true.
Is Dr. Halford going to be at that seminar?
I don't have the roster of...
Do you know Dr. Halford?
The name is familiar to me, yes.
Okay, and do you know if he's a professor of neurology?
I'm sorry, I don't know South Charleston.
And all right, well, if you don't know, then I won't continue with the questions. Thank you.
Yes, ma'am.
Thanks, Senator.